I will be presenting today the chapter titled Negotiating Multiple Meanings of Vulnerabilities in Lebanon's Compounding Crisis, Refugees Encounters with Framework and Institutions. This chapter was written by my colleague Catherine Brun and I. I will be tackling, I will try as much as I can go as fast as much as I can. First, starting by the historical background of the compounding crisis in Lebanon, then trying to understand the vulnerability concept and the encounters between refugees, institutions, and framework, skipping quickly to the methodology, and then the encounters with the bureaucratic and legal frameworks, and consequently, the encounter with the institutions and the different responses to refugee, and try to discuss the experience and production of vulnerability and the institutional encounters, and to conclude by the recent impacts on vulnerabilities amid the current Israeli assaults and aggression on Lebanon. First, it's very important to set the stage for our research findings, to begin by emphasizing the historical background of Lebanon's compounding crisis, as it's provide the necessary context to fully understand the complexities and implications of our analysis. Lebanon is known for its cascading crises, starting by the political crisis such as the civil war in the 1975, the many Israeli invasions to Lebanon, for example, the war of July 2006, and ended by the recent Israeli aggression on Lebanon, which has intensified since 23 September 2024 and resulted in 3,555 martyrs and 15,123 injured, and more than 1.3 million people displaced. And the attacks on the civil people in the infrastructure, healthcare system, medical staff, and lots of other attacks. The deep financial and economic crisis starting the 2019, and it's as per the World Bank data, it's possibly to be ranked on the top 3 most severe crises. The COVID-19 pandemic with its intermittent lockdowns and the Beirut blast explosion on 4 August 2020, pushing the population further into depression, poverty, and insecurity. And the long history of migration, both receiving the diaspora, large diaspora population, and the 3 main refugees movement to Lebanon after its independence in 1943 was the Palestinian, starting the 1948, the Iraqi refugees in 2003, and the Syrian refugees in 2011. Now, the research in Lebanon showed that the vulnerability is understood and applied both as a premise, since the institution assume refugees are vulnerable and shape their policies and approaches accordingly, and at the same time as an outcome, since refugees' interactions with these institutions often reinforce or increase their sense of vulnerability. Also, it showed that the vulnerability is a label and a category used by the aid organizations and the state to allocate aid and decide on resettlement to a third country. But the critique to this approach, it creates a stigmatization and regulation of certain population. Also, refugees' experiences of vulnerability may be termed as epistemic vulnerability, which is deepens inequality and inflicts harm. And as per the refugees' reflection, the context has more dynamic, multidimensional, and contextual approach, and it's more situational vulnerability that can happen to anyone at any given moment. Now, when studying the encounters and the interface, and to understand the encounters in the Lebanese case and why encounter, to focus on the agency that refugees may pursue in these encounters. And in Lebanon, it includes the refugees' direct interactions with governance, assistance, and protection structures framed by broader power relationship. And also, it showed that the double meaning of vulnerability. First, the categorization of refugees are vulnerable, and second, their experience of epistemic vulnerability shaped by the institutional framework. And the analysis in the chapter aimed to explore how refugees maneuver and mobilize constraint agency within restrictive and often hostile institutional contexts and amid Lebanon's financial and political crisis, like we will show in detail later. Quickly regarding the methodology used for this chapter, the data were collected during two different time periods. The first phase for when writing the first vulner report from February to November 2020, and the second phase from July 2021 to October 2021, where we did the semi-structured interviewed with the judged officials, UN agency and lawyers, and for the second phase with the refugees themselves, Syrian refugees, Palestinian refugees from Syria, and Palestinian refugees from Lebanon. And it's very important here to note that all findings are limited to the study period up to 2021 and do not reflect the recent escalated situation in Lebanon, which has further intensified the vulnerabilities of everyone living in the country. When it comes to the encounter with the bureaucratic and legal framework, it's very important to note that Lebanon is hosting the most refugees per capita in the world. It considers itself a transit country and not a host country. It's not a signatory to the 1951 Refugee Convention and lacks a legal refugee regime, resulting to sporadic and ad hoc policies and decisions, and does not acknowledge the possibilities of seeking refugees in Lebanon. Hence, all displaced population reside officially in Lebanon temporarily. And Lebanon's approach allow for treating and categorizing different refugee groups differently. For example, Syrian refugees, and we are talking here in the public discourse, and not in the legal framework. Syrian refugees are referred to as displaced. Iraqi refugees are referred as foreigners or illegal residents. Palestinian in Lebanon are referred to as refugees. So we can conclude that the refugee term is very politically labeled. Now, how these different refugees categories encounter the bureaucratic and legal framework already mentioned. The Syrian and Palestinian refugee from Syria, mentioned here as PRS, the abbreviation, they are treated as foreigners. They must navigate the same costly residency process as other foreigners, and this has resulted in over of 80% of those aged 15 and above to lack legal residency in Lebanon, as per the vulnerable assessment done by UNHCR. And also regarding the work permit, they require a costly work permit or a sponsor, often leading to exploitation due to dependency and limited access to certain professions. Now, for Palestinian refugees in Lebanon, they lack Lebanese citizenship and are treated as foreigners. They are excluded from political, social, and economic participation, with many lacking formal residency status, and they can work based on their residency status, but face restriction on the type of job they can hold. So we can see that the refugee frameworks create situational vulnerabilities by restricting refugees' livelihood, property ownership, and social integration, and limiting their rights and autonomy. Now, in the next slide, we will show the experience of encounters with different institutions resulting from the fragmentation of the response from various state and non-state actors, and resulting in a security approach, which focused on monitoring and restricting movement, and a humanitarian approach providing basic survival aids. So while there are few similarities in the experience of encounter, also there are lots of differences as well among the different group of refugees. First, when it comes to the security response, the encounters with security actors also for Syrian refugees and Palestinian refugees from Syria when it comes to dealing with the general security, which is the authority monitoring entries and stays and residence and departure in Lebanon. Since most of the Syrian refugees, as we showed, are without legal residency, so there were not much dealing with the GS in recent years. When it comes to the Lebanese army forces, before COVID-19, we mapped lots of arbitrary detention, torture of refugees, raids of settlements, resulted in detaining refugees lacking legal residency, possibly due to expired permits. When it comes to the local institution, which it's mainly the municipalities, they are at the forefront of responding to the Syrian refugee crisis, managing livelihood services and tension mitigation. Also, in the Syrian informal settlements, there is a person called Shawish, who serves as a settlement supervisor and a link between refugees, Lebanese authorities and organization, and it which creates a complex relationship with the refugees. Now, for Palestinian refugees, also, when it comes to their dealing with the general security, many of them experience bureaucratic obstacle and significant influence over their legal status and movement. A new encounter for the Palestinian refugees is their encounter with the security committees and the popular committees in the Palestinian camps. There is lots of political affiliation and power dynamics in the camps, which create a protection challenges for Palestinian residing there. Now, when it comes to the humanitarian response, the encounter with different humanitarian actors, especially the UN agencies and civil societies. The Syrian refugees and Palestinian refugees from Syria, when dealing with UNHCR, they experienced a communication gap, a confusion about aid and resettlement criteria, and mistrust in the organization, which has led to the increasing of their vulnerability and a sense of to be neglected. When it comes to the Palestinian refugees dealing with UNRWA, also they report inconsistent communication and access to aid due to the funding storage to UNRWA, and they mentioned lots of favoritism, which undermine the effectiveness of the assistance provided. When it comes to the dealing with the international organizations, they were trying to fill the gap left by the state, providing aid like accommodation support. But for the refugees, they felt that they often failed to meet their promises and lots of irregular follow-up, causing refugee frustration, maybe due to funding cuts. The funding cuts has changed also their eligibility criteria. And finally, moving to the civil society organizations, they provide varied levels of support, but the Syrian refugees reported better access than Palestinian refugees. And during COVID-19, most of them switched and shifted their response to remote method, complicating communication for refugees, but most of them tried to make effort to improve their outreach via mobile units, for example. Now, the discussion about, resulting from all the previous information, how the experience and the production of vulnerability in the encounter of the institutions. First, we see the ontological experiences of vulnerability, where refugees expressed feeling of being left alone, lacking help and support with no state representation. Also, the confusion about eligibility criteria and irregular support. Now, regarding negative coping strategy, in our book chapter, we criticized using this concept because it's by using it, we are focusing more on individual responsibility while ignoring the systemic creating vulnerability. So we prefer to use the coping and constraint agency concept to refer how refugees are navigating institutional barriers and leveraging social networks for support. One of them, the social capital, helped a lot. And at the end, the uncertainty and epistemic vulnerability, the sense of the constant uncertainty among all refugees because of the prolonged crisis. In the conclusion, we concluded that there is a dual approaches to vulnerability and ambiguity of the vulnerability concept. It's used differently across institutions, often serving their own interest, leading to inconsistent application. Also, there is an institutional fragmentation in the refugee crisis responses, which create the ambivalent relationship with relevant state and non-state institutions vis-à-vis the refugees, the lack of accessibility to protection and assistance in refugees encounter, and the Refugees Agency, which is the constraint agency and room of maneuver. Despite the hardship, refugees demonstrate potential agency and strategies to navigate restrictive institutional framework. And at the end, there is a need for the institutions to better understand the notions of vulnerability in alignment with the refugees' real experience for improved assistance and protection. The last slide, it's a reflection on the current situation in Lebanon amid the latest Israeli murderous assault in Lebanon, how it's impacting the vulnerability of all people, Lebanese and non-Lebanese. Absolutely, there is an increasing in the situational and ontological vulnerabilities, mostly the mental health issues, the increase of safety concern and fear, and the feeling of stuckness. The constant uncertainty is still ongoing. The causalities and displacement, as I mentioned, so far as per the World Bank data, more than 1.3 million people are internally displaced, and from them there's people who were displaced to Syria and to Iraq. And we mentioned the lack of shelter and barriers to essential services, increasing the exposure to violence and risk. And there is an assumption from the World Bank, the November report, the latest one, that women, children, elderly persons with disabilities, refugees, and some migrant workers are particularly among the most vulnerable ones. And at the end, the Lebanese State's National Emergency Plan announced on the 31st of October, the plan made the limited reference to migrant and refugee communities. Instead, there is a delegation for the international organization, mostly IOM, UNHCR, UNRWA, and UNICEF, to the responsibility of supporting these vulnerable population, leaving them without direct state support. And thank you so much for your attention, and hopefully I stayed within the time limit.
Yes, you did. Thank you so much. Shall I give the floor now perhaps to Denise so that she can share a little bit with us about the vulnerabilities faced by LGBTQI+ asylum seekers?
Thank you. Just 1 second so I can share my presentation.
Sure.
Okay. So you should be able to see it.
Yes, we do. Yeah.
Yeah, just give me 1 second. Okay, so I can put it. Okay. So thanks a lot, Daniela, and thanks a lot to Luke for involving me and for inviting me. And thank you very much, Maria. This was really super, super interesting. And I'm looking forward to the questions. Now, I think that with my presentation, we go to, well, connected topic, but to a different context and also to some extent different methodology. So what I'm presenting here, as you also Daniela mentioned at the beginning, is my article, which is published in the European Journal of Migration and Law, in which I deal specifically with the concept of intersectionality and how it can be a useful tool when it comes to asylum claims based on sexual orientation and gender identity. And in this article, I put together some results from my PhD, from the fieldwork that I conducted for my PhD, and also some results of the fieldwork conducted by the Volner researchers, for which, of course, I'm very grateful for their work, because I see, as I will explain in a bit, how, let's say, the results from both fieldwork, they enter into a dialogue when it comes I mean, in general, with regard to vulnerability, but specifically also when it comes to application based on sexual orientation and gender identity. I will use the acronym LGBTIQ+ during my presentation, and also SOGIESC, just to signify sexual orientation, gender identity, gender expression, and sex characteristics. But essentially, I'm referring to asylum claims, which are presented due to persecution based on sexual orientation and gender identity. And what I do in my article, I essentially start with a real case, of course, with names anonymized and so on. So with a real case drawn from a real life experience, so starting from the people. And there is this dialogue of a man seeking asylum and struggling with presenting his claim because it is based on sexual orientation and gender identity. And having also worked as a practitioner in this field before, let's say, turning to academia on this topic, this was something that I always encountered in my work. And starting from this, I start digging a little bit further on the challenges that LGBTIQ+ asylum seekers may face in the asylum procedures, and how intersectionality can be a useful tool in this regard, but also to some extent, which can be also the limit to operationalize this concept, as I will explain. When it comes to intersectionality, and I'm sure that Luke will talk a little bit more about that, we usually equate intersectionality to layers of complexity. There seems to be some sort of rhyme between intersectionality and complexity and layers of complexity. And when it comes especially to SOGIESC, SOGIESC factors are one of the layers that actually compose the identity and the experiences of each one of us. When it comes to SOGIESC in asylum, there is a reference to vulnerability because of SOGIESC, both in the law and in the policy. And usually, this is equated with procedural guarantees, especially when it comes to the Common European Asylum System, which is the focus of my investigation. So, of course, as I said, SOGIESC factors, they may give rise to special procedural guarantees. They are factors, let's say, of vulnerability to be taken into account, but there are also other layers that impact on SOGIESC and on the way in which SOGIESC aspect may or not may be expressed, narrated, and also experienced throughout the asylum procedures. So this factor, they shape SOGIESC, but also the way, again, in which SOGIESC is experienced by applicants. When it comes to, let's say, the legal framework, there is a reference of intersectionality in many soft law instruments. You can see some of here in the slide. I'm not going to go in details in all of them, but this is just to say that in many cases, intersectionality is not expressly spelled out. There is more, let's say, more frequently a reference to compounded factors, to overlapping factors, intersecting factors, multiple layers, as I was saying before. What I think it's interesting is that, especially UNHCR, over the years has taken, I would say, a more explicit stance on intersectionality in recent documents. For example, now we find an express reference to intersectionality to be used as a useful concept in asylum, and specifically also when it comes to claims based on gender, sexual orientation, and gender identity in UNHCR documents. For example, the documents on working with LGBTIQ+ people in situations of forced displacement, or in the age, gender, and diversity approach by UNHCR. So on this, also the work of the CEDAW committee has been particularly interesting from this point of view, regarding let's say, the obligation of states to so to say, to recognize the intersecting form of discrimination when it comes to gender-related claims. Of course, as I said before, these instruments are not legally binding, but they are nevertheless authoritative, as I think we all know, both when it comes to CEDAW, but also when it comes to UNHCR guidelines and guidance, given UNHCR supervisory role vis-à-vis the Refugee Convention. The next step that I try to deal with in my paper is if we can find any trace of intersectionality in EU asylum law. And again, I mean, perhaps unsurprisingly, there is no direct reference to intersectionality when it comes to EU asylum law, I mean, in general, but also with regard to gender, sexual orientation, gender identity. Nonetheless, there is a reference to the fact that application needs to be examined on an individualized basis. And this is true not only for the first, let's say, part of the examination of an asylum application, there is the credibility assessment, but also for the second part on the legal analysis. So the second part that takes place once we have established that a claim is credible, and we move on to assessing whether that person meets the eligibility criteria for refugee status. So in Article 4, Paragraph 3 of the current qualification directive, there is an important reference to assessing all the elements, so to say, of the individual cases that can be relevant for an asylum application, including elements related to gender and age. And this is also retained in the qualification regulation under the EU Pact. So although we cannot, let's say, equate to occur an individualized assessment to intersectionality, nonetheless, individual assessment is necessary a starting point to advocate for the need to apply an intersectional informed approach, because only an approach that is truly intersectional will be also individualized. And just to add that in the new EU Pact instrument, elements regarding to sexual orientation, gender identity are now expressly included among the factors that can give rise to special reception needs and special procedural guarantees. So there is even more an acknowledgement of this link that I was mentioning before between, so say, SOGIESC and factors leading to vulnerability and specific needs. Now, moving on to the second part of my presentation, which is also the last one, I would like to present you with some insights from intersectionality in action with regard to the case study of Italy, which is the case study in which I focus my PhD, drawing also from my experience as a practitioner here. I think that the case of Italy is quite interesting from this point of view, because although, again, unsurprisingly, perhaps intersectionality is not yet there in the legal reasoning, nonetheless, the Supreme Court, the Court of Cassation, has consistently reiterated the need for decision makers to apply an individualized assessment and to adopt an individualized approach to the examination of asylum application. And throughout the years, the Court of Cassation has always been consistent in, let's say, putting forward this remark. So at the beginning, this principle was, let me put it like that, like well established, but not properly like explained, unfolded. Whereas instead, in more recent judgment, we see a sort of an evolution, and the court being more, I would say, more open and more proactive in underlining how other factors, for example, the overall background of an applicant, also the age, the social background, can have a bearing on how an applicant is able or not to talk about sexual orientation and gender identity. And in some more recent judgment, also the court has acknowledged also the impact that factors such as shame, intimacy, or hesitancy can have the applicant's ability to talk about sexual orientation and gender identity. This may be also, I mean, so to say, a sort of a domino effect from the Court of Justice of the European Union, which actually has also put forward this principle. But what we see in the jurisprudence of the Court of Cassation of the Supreme Court in Italy, it is what you can see on the right-hand side of the slide. So the crystallization of a key guidance on the need for an individualized approach, which prompts better credibility assessment, and the relevance of a multi-layered dimension of this analysis of all factors composing an application, which in turns can go to the enrichment of the legal reasoning. What I try to do in my paper is to illustrate how that has worked in a specific case, which of course does not mean that this is always what happened in the case law in Italy, but we start seeing some, let's say, positive examples of a more intersectionality informed reasoning. So in this case, which I analyze in depth in the paper, essentially a court of first instance quashed a decision taken at the first instance of the administrative stage, which declared the applicant not credible because the declaration on his sexual orientation were inconsistent, incoherent, and so on. Whereas instead, the court looked at the fact that when the applicant underwent the first interview, he was very young, he didn't have any sort of legal counseling, and also there was a sort of language but also cultural barrier which actually prevented the applicant from fully expressing these claims. So the decision of the court of first instance in appeal is actually structured around how these factors prevented the applicant from fully expressing their claim and actually eventually decided to recognize a refugee status. So the judgment really details the impact that this factor have, which is to me something that goes a little bit beyond the individualized approach, but really motivates on how this factor impacted and, so to say, constrained to some extent also the applicant's narrative. So moving towards the conclusion, I think that what we can grasp from the empirical research are that there are also other factors that should be taken into account when examining claims based on SOGIESC, whereas instead sometimes the tendency is to focus only on sexual orientation and gender identity, but intersectionality helps open a bit the eye and can be used as a lens to read through the applicant experiences, and also is a way of embracing complexity. And what I mean by that is that the trend or the tendency would be to move towards models or methods for assessing credibility, which are, for example, based on a set of questions, on country of origin information research that can be like a basis for the decision making, which are of course important, but they should not be prevented the decision maker from really embracing the complexity of a claim and try to detach a bit from the, let's say, the tendency of sticking to that model and pretending that all narratives that fit into that model. Of course, this let's say poses some challenges when it comes to sustainability and effectiveness of this, because it requires skills from the point of view of decision makers. So they need to build the skills to make these skills sustainable in the long term, especially in a moment of high pressure on asylum systems and problems from the point of view of really managing complex claims in a shorter time frame, as we will also see with the new EU Pact. What I think it's interesting, and here I conclude, when it comes to putting the vulnerable data, let's say, in a dialogue with the data that I got from my fieldwork, is how intersectionality can be a useful tool not only for the phase of credibility assessment and legal analysis in the refugee status determination, but actually what vulnerable data suggests when it comes to SOGIESC is that intersectionality is a tool to read throughout the whole displacement cycle when it comes to LGBTQ+ applicants, in the sense that all experiences and all challenges that these applicants face, for example, in countries of origin, in transit, but also in the country of asylum, that will have an impact on how they will be able to deal with the phase of the asylum procedure, and precisely of the refugee status determination. And so I think I pretty much relate to what vulnerable researchers have written regarding the need for an intersectional gaze when it comes to understanding the experiences of LGBTIQ plus asylum seekers in a way that move also beyond credibility assessment and also suggests, and this is something also that comes out from my fieldwork, the usefulness of intersectionality also to understand the concept of persecution. So also to understand what can amount to persecution in a given case. So in terms of like key messages that to me are like important maybe to remember from today is that intersectionality is there. There are plenty of references to an intersectional informed reasoning in software instrument, but also there are grounds for that in the legislation that we can leverage to move forward with this approach. And intersectionality can be a tool to better understand the experiences of people applying for asylum based on sexual orientation and gender identity. So as a way also to read and to unpack the concept of vulnerability. I think I can stop here. Thank you very much.
Thank you so much, Denise. And I think that now I will give the floor to Luke, who will discuss about vulnerability as transitioning from the ethical perspective and analytical approach to the bureaucratic label.
Well, I'm sorry, I'll have to leave and come back because I cannot share my screen. So, sorry.
Okay, then maybe meanwhile, until Luke comes back, I can already open the floor in case any of you have any questions or comments regarding Maria's presentation or Denise's presentation. I'll have a look at the chat as well. Rafaela, please go ahead.
Okay, hi. Just one quick question, because from my understanding, basically it was a European project and all of you are looking at vulnerability. So my question is whether you have come across with like a definition of vulnerability. And the reason I'm asking this also because from the first paper from Maria, actually one point that she said that rather than talking of vulnerability, the key question was to talk about coping strategies. So in that sense, a question of agency. So in that sense, you have highlighted the ability of refugees to respond to the situation. So my question again, like, what is the meaning of vulnerability that you are applying? And is there a different meaning according to the different context that you have used? Thank you.
Thank you, Rafaela, for your interesting question. So, and this question was for a long period within the Foreigner project, studied from all the countries involved in the project. And as per my point of view, so the vulnerability as a concept itself is very ambiguous, and it has a multi-dimensional dimension and multi-dimensional and many meanings. So when it comes to asking, for example, in the first phase, the people working within the legal and bureaucratic framework in Lebanon, they has a many definition of vulnerabilities. And when it comes to the refugees themselves, when asking them about the vulnerability, they have different perspective of the vulnerability. And this what we try to mention here, the gap between the legal and bureaucratic framework and the refugees themselves. When the refugees say, when I'm feeling alone, or when I'm feeling unsafe, or when I'm feeling stuck, this is the vulnerability for me. But for example, a lawyer said another concept, maybe the lack of a legal framework. So two different perspectives creating this multi-dimensional and multi-layered. So as a conclusion, there is no one final definition of vulnerability at the end.
Thank you, Maria, and thank you, Rafaela, for your question. Luke, I see that you are back. I don't know if now it works to share your screen. Maybe we can try, and we'll come back to the Q&A after your presentation. We cannot hear you, Luke. Okay,
All
now
right. I hope everything is fine now. Okay,
Yes.
my apologies. New computer, new university, and settings that needed to be adapted and adjusted. Thank you very much, Daniela, for the invitation and for the organization of this webinar. Thanks a lot also to both Maria and Denise for the very interesting presentation. I've heard your work so many times, and it's always extremely interesting because every time I have the feeling that I get to another level of understanding. So thank you very much for your talk. What I will do with my presentation is actually trying to come back a bit on this very notion, on this very concept of vulnerability, and I'll do so based on one of the chapters which was published in this book, which is one of the main outputs. There are many other outputs, of course, because there were many people in this project, but one of the main outputs of the VUNER project was this book, which tries to kind of summarize the findings of the different teams and the different researchers that were involved in this project. And one of the chapters, and which is the chapter I wrote, deals a bit more with this concept of vulnerability, which I try to do while taking as starting point that given that vulnerability is increasingly used and mobilized in asylum laws and policies, especially at the UN level when it comes to identifying aid beneficiaries, and at the EU level when it comes to identifying those who will have access to a legal status. And I think you have had a very good example of that with Denise's presentation. Then it should be interesting to think a bit more about the concept itself. Because of course, we can understand and accept that there is some kind of vagueness around the notion, and that's also the richness of it. I'll get back to that. But when it comes a concept and a notion that's used to identify people who get access to some kind of welfare services or to a legal protection status, then you have to be very aware of what's going on and what kind of impact this will have on people, of course. And when you start designing asylum laws and policies around this kind of notion, which is new in the legal framework. So I insist on that. So what I did to reflect a bit on that in that chapter is actually to have a look at how the concept of vulnerability itself evolves and receives different meanings depending on the conceptual frameworks within which it is used, invoked, and mobilized. I identified for the purpose of that chapter 3 different frameworks. The first one being the ethics framework, and that relates to all those theories of justice that mobilize vulnerability as a moral argument to justify some kind of state duty to act and to protect some people on account of their vulnerable position. I'm referring here to ethics of care, among others, who have made a great deal of work of thinking about vulnerability and conceptualizing vulnerability as a moral ground, as a moral justification for states' obligation. Another framework in which vulnerability is used and mobilized is a bit more the heuristic framework. And that's a framework that's very closely connected to the ethics of care, actually, because you have a lot of research, including as part of the VUNER project, that has been done and that uses vulnerability as the kind of heuristic angle, as the analytical framework to better understand human experiences. In these studies, vulnerability kind of serves as an analytical tool that will allow the researcher and the scientist to show the complexity of human experiences. And then you also have the legal framework in which vulnerability is used in 2 different ways, by analyzing the laws in the EU and by analyzing the case law of the European Court of Human Rights and the European Court of Justice. I came to the conclusion that there are 2 different approaches to vulnerability in law. A first one is an approach that's focused on specific or special needs, which means that you kind of reduce vulnerability to some kind of abstractly defined characteristic such as age, gender, health, etc. With, of course, the advantage that you can very quickly identify those vulnerabilities and act upon them, but also the disadvantage that you have a very sanitized approach to vulnerabilities that's quite disconnected from people's experiences. And another approach that can be found in the legal system, and that's a bit more in the case law of the European Court of Human Rights and the European Court of Justice to some extent as well, is an approach in which vulnerability is a kind of loose notion that the judge will use to ascertain the legitimacy of its ruling, that the court will use to kind of legitimize the conclusion it takes when it comes to recognizing some rights to some people, with the risk and the negative aspect, if I can say it from a legal perspective at least, that this notion then is very loose, so it doesn't bring a lot of legal certainty. There is not a lot of systematization of the use of vulnerability in legal reasoning, to the extent that you don't really know what the concrete consequences of having someone identified as vulnerable. And another issue, of course, is that you don't have a specific process that will allow you to identify who is vulnerable when you have a bit more this loose approach to vulnerability. Now, when we look at these three different meanings of vulnerability as a moral argument in the ethics framework, as a heuristic device in the heuristic analytical framework, and as a tool that will allow you to identify who will get access to some kind of specific services, well, then you also have to understand that this different framework impact each other. And what I mean by that is that vulnerability has some implied meanings depending on the framework in which it is used and mobilized, and that this implied meaning will travel together with vulnerability as it evolves from one framework to another one. Let me give you just a very concrete example. In the ethics framework, vulnerability is very much conceptualized as something individual. So the focus is on individuals and the kind of sufferings they face in their specific individual situation, given their specific position in society. And that's something that's taken over in studies that mobilize vulnerabilities quite often. They take the individual as starting point and they try to identify what are the different factors that can lead to that individual being particularly vulnerable. Yet, when you have this kind of approach, you also have to be very careful about not forgetting the structural factors that lead to some people being vulnerable. When you focus on individuals, that's a good thing, of course. That can be a good analytical angle to better understand their experiences. That's also a valid moral argument, but it can also lead you to a situation in which you forget about the structural factors that have the impact of putting someone in a vulnerable situation. You can correct that in research, and a lot of writers, scholars that mobilize vulnerability do it. But when you transfer that to the legal framework, please don't forget about it. And that's kind of the risk. The risk is that you forget about the structural factors that put people in vulnerable situation, and you only look at the specific situation of one individual and at their own characteristic, because that's something you can identify quite easily, and that's something that will allow you to take a decision very quickly. Well, this can have an added value, but don't forget that these are structural factors. Another example which is related to that and which is maybe a bit more controversial as well is the strong focus on the gender dimensions of vulnerabilities that can be found in the ethics framework and in the heuristic framework. That focus is justified. I'm not questioning that. Gender dimensions are important when you talk about people's vulnerability. But not everything is about gender. And when you move into the legal framework, there is a danger at limiting vulnerability to the gender aspects, because then you have something that you can identify quite easily and forgetting about the other dimensions of migrants' vulnerability. And finally, maybe one last example, which is, in my view, maybe the most worrying one, at least from a legal perspective. And that last example concerns the implied meanings of victimhood that you have behind vulnerability. When you mobilize vulnerability, especially as a moral argument, then you also imply that these people are kind of victim of the current system, and that's why you should have state action in view of correcting these inequalities that put these people in a situation in which they become victim of the system. And that might make sense from a moral perspective, and that might also give you very powerful arguments when it comes to advocating for some kind of state action to reduce the vulnerability, or at least to try to mitigate them. But when it comes to using vulnerability then in the legal framework and in the policy framework more generally, if you have too much of a focus on victimhood, on who's the victim, then you kind of risk losing track of rights. And you have quite a few examples right now in the way policies are being developed, where we focus on deservingness of some group that deserve protection, which is not a bad thing in and by itself, but which becomes problematic when this discourse on deservingness takes over a rights-based discourse, which is focused on implementing rights. The difference between the two being that when you have a right, well, and the conditions are fulfilled, then you're entitled to benefit from that right. Whereas when you focus yourself on who deserves to protection, then you kind of loses this connection with a rights-based approach, which doesn't require you to ask yourself whether someone actually deserves some kind of additional protection. Now, of course, that's a discussion that exists nowadays, especially among lawyers. Should we then ditch vulnerability as a legal concept? Should we completely ditch vulnerability as a tool for asylum governance, with some advocating with quite interesting argument that vulnerability should in the end remain in the heuristic and framework and the moral framework, the ethics framework, as a way to develop some kind of radical criticism of migration policies, of their effects on people, and that you should avoid, integrating them in asylum laws and policies, because then you get all this kind of negative effects I've just described. I'm not actually fully sure to be in agreement with that. I agree that there is a real humanitarianism trap we need to be aware of, meaning that we should not fall into this issue of discussing deservingness and losing track of rights. There are some rights in international law, they need to be respected, irrespective of whether someone is more vulnerable than others. There are asylum seekers that are more vulnerable than others, but the rights of all asylum seekers should be respected. And yet, on the other hand, if you're aware of that, vulnerability also offers you some kind of background to bring into legal reasoning all that empirical knowledge on migrants' vulnerabilities that has been developed by many scholars, including colleagues as part of the Wiener project, when you're implementing the law in individual cases. And what I mean by that is that there is always a gap, of course, between the law, the text, and its concrete implementation in individual cases. And one way to fill the gap will be to rely on vulnerability, because it will then allow decision makers to actually consider the experiences of people, to actually consider the difficulties they face when implementing the law in their individual cases, which will in the end sustain, maybe that's a hope, a decision-making process that's a bit more fair, because it's more connected to the realities of the people seeking protection. So thank you very much. I'm aware this was very dense. It's just a snapshot of the chapter, so please have a look. And the chapter also actually doesn't make sense if you don't read it together with the other chapters of the other authors who did also a lot of research and thinking on this very concept of vulnerability. But thank you very much again for listening to me, and I'm very happy to discuss with you.